Employment law helplines versus employment law solicitors. Which one is better for support in SMEs? Most small and medium-sized enterprises assume that having an employment law solicitor on call is the fastest way to handle issues, but the surprising truth is that employment law helplines can provide immediate, cost-effective support for day-to-day queries. Employment law solicitors are essential for complex cases, such as employment tribunal claims, wrongful dismissal disputes, or high-stakes contract negotiations. They provide detailed legal advice, draft documents, and represent companies in formal proceedings. However, engaging a solicitor for routine requests like holiday entitlement, flexible working requests, or minor disciplinary matters can be expensive and slow. Employment law helplines, in contrast, offer instant access to expert guidance for a wide range of everyday issues. They provide practical advice, sample templates, and step-by-step instructions, allowing managers to resolve issues quickly and confidently. For example, if an employee requests parental leave unexpectedly, a helpline can guide the team on legal obligations, documentation, and timing within minutes, avoiding costly mistakes. The key difference is scale and immediacy. Solicitors deliver detailed, case-specific legal expertise, while helplines provide rapid, practical guidance for common scenarios. Many SMEs adopt a hybrid approach. Helplines handle routine queries, freeing up time and resources, while solicitors are reserved for complex, high-risk situations. The takeaway is clear: employment law helplines improve efficiency, reduce costs, and empower teams in SMEs to handle compliance confidently. Solicitors remain critical for strategic, complex, or contentious cases. Surprising truth is that fast, practical advice doesn't always require a formal legal appointment, it just requires the right resource at the right time.